3, 2, 1. This appeal is directed against an order passed by learned single judge of the High Court of Karnataka at Bangalore in second appeal number 68 of 1994, whereby learned single judge by his order dated October 17, 1997 has allowed the second appeal of the defendant number 1 and set aside the order passed by the trial court and the first appellate court and dismissed the suit filed by the plaintiff for specific performance but decreed the suit of the plaintiff for the alternative relief for refund of the purchase money of rupees 15,000 with future interest, and the court costs from defendant number 1 aggrieved against this order. The special leave petition was filed by the plaintiff. Full stop para. Brief facts for disposal of this appeal are that the defendant number 1 was the owner of the suit property, which is a house bearing HDMC number 715 comprised in CTS number 1529/16C situated at Hubli. Full stop. Defendant number 1 agreed to sell the suit property to the plaintiff on March 13, 1981 for a sum of rupees 15,500 and received in advance of rupees 2,000 and executed an agreement for sale agreeing to execute the sale deed within 2 months after obtaining necessary permission. Full stop. The plaintiff assisted the defendant number 1 in obtaining necessary permission from the competent authority. Full stop. But defendant number 1, after getting necessary permission for sale, failed to execute the sale deed, accepting the balance consideration money of rupees 13,500 from the plaintiff. Full stop. Defendant number 1 took the plaintiff to the sub-registrar's office on February 23, 1982 and persuaded him to purchase the stamp paper, but defendant number 1 escaped from the office of the sub-registrar when the sale deed was about to be registered. Full stop. The plaintiff was ready and willing to perform his part of the contract according to the terms and conditions of the agreement of sale on March 13, 1981. Full stop. In spite of requests by the plaintiff, defendant number 1 did not execute the registered sale deed, receiving the balance amount. Full stop. Hence, the suit was filed for specific performance of the agreement by the plaintiff, and in the alternative, the plaintiff also prayed if the court were to come to the conclusion that specific performance cannot be granted, then a decree for refund of the earnest money, including the cost of registration and damages to the plaintiff, should be awarded. The plaint was subsequently amended on account of the new facts coming to the light that defendant number 1 has executed another agreement for sale in favor of defendant number 2 on March 8, 1982. Full stop. The plaintiff got a news item published in Vishwavani, Delhi on March 24, 1982 about the earlier transactions between himself and defendant number 1 with respect to the suit property. Full stop. But defendant number 1 and 2, with an intention to defeat and defraud the plaintiff, filed another collusive suit being OS number 101 of 1983 before the Munsif Hubli and obtained a compromise decree. Full stop. By virtue of the said compromise decree, defendant number 2 obtained the sale deed from defendant number 1 in respect of the suit property. Full stop. Therefore, the plaintiff amended the plaint and implemented defendant number 2 and prayed that the collusive decree obtained by defendant number 1 and 2 is illegal, void, and not binding on the plaintiff. It was further prayed that defendant number 2 was also bound to execute the sale deed along with defendant number 2 and hand over possession of the suit property. थैंक यू फॉर वॉचिंग आवर वीडियो। अगर आपको हमारा ये वीडियो पसंद आया है तो ज़रूर शेयर करें, लाइक करें एंड सब्सक्राइब करें।